Hi, I'm Casey. I am a professor and I'm an expert on copyright and fan works. So let's learn about fair use with wolf erotica. Believe it or not, I was actually planning on filming a video today about why fan fiction isn't copyright infringement. And I even thought that might be a good way to explain fair use to people. And then this happened.
So a few months ago, there was this article in the New York Times with the title, "A Feud in Wolf Kink Erotica Raises a Deep Legal Question." Subheader, "What do copyright and authorship mean in the crowdsourced realm known as the Omegaverse?" And I gotta tell you, this article doesn't even come close to scratching the surface of how coconuts this whole thing is.
Or actually, that happened about a month ago. Lindsay Ellis, the video essayist, made a video about a copyright lawsuit. But then the day before I was filming this video, this happened.
You see, Addison Cain has sent a DMCA takedown notice to Patreon demanding that I take the post about Omegaverse down.
Objection!
So basically, this is a video explaining fair use. But it also happens to include, as a case study, this totally bonkers fact pattern about YouTube videos, criticism, and excerpts from wolf erotica. And as a bonus, let's just say, questionable analysis of why something isn't fair use in response to YouTube denying a takedown request. Questionable enough that it made me want to make this whole video, and trust, I've seen a lot of questionable fair use analyses. To be clear, you definitely do not need an understanding of fan fiction, wolf erotica, the Omegaverse, or that particular lawsuit in order to grok this video. However, if you're planning to watch Lindsay Ellis's videos about this, you might want to do that first. Especially because, also to be clear, I'm not commenting here on the original copyright lawsuit. Whether another author infringed Addison Cain's copyright is totally irrelevant to whether Lindsay Ellis did. So you can watch Ellis's first video and make your own judgment on that. And if you're only interested in hearing me explain what fair use is, then you can skip all the wolf erotica details and go straight to the timestamp that I'm going to put right here. But briefly, my credentials and some caveats, because boy, are there a lot of copyright experts on the internet. I do have a law degree, and I specialized in intellectual property and internet law. But even though I passed the bar exam, I went straight into a PhD program and have never practiced law, and have no real desire to practice law, and I'm not licensed by any bar right now, so, you know, this video is not legal advice. But I did write an entire dissertation about copyright law, online platforms, remixers, fan works, and why fair use is so hard. I have never felt so qualified to weigh in on something in my entire life. I am also on the legal committee for the Organization for Transformative Works, or OTW. We protect the legal rights of non-commercial fan creators. But they actually have nothing to do with this lawsuit, and also nothing to do with this video. They don't even know I'm making it. Now, there is so much to unpack in this story. Filing the serial numbers off fan fiction, copyrightability, and ideas versus expression of ideas, DMCA takedown notices and how they can be abused. Now, I'm not going to give you a rundown of the Omegaverse lawsuit because Lindsay Ellis's videos did that in far more detail than I could do here. I'm just going to give you enough information that you can understand this fair use analysis. The fact pattern, if you will. So Lindsay Ellis, the video essayist, made a video about a copyright lawsuit. The details of that case actually aren't all that relevant here, except that it's ironic that in the end that case is in part about inappropriate DMCA takedowns. The major player here is author Addison Cain, a pseudonym, the author of Born to be Bound. She published some books that originally started off as Batman the Dark Knight Omegaverse fanfiction. What is Omegaverse? Well, it's a fanfiction trope, and it has to do with wolf mating habits, and you can watch Lindsay Ellis's video if you want more on that. But to be clear, Addison Cain's books, not copyright infringement. Not any more than 50 Shades of Grey was copyright infringement of Twilight. Why that is would be the topic of an entire video, but it has to do with basically what you can copyright. In any case, sometime after Cain published this book, a DMCA takedown notice was sent to the author of another book, with Cain claiming that it infringed on her copyright in Born to be Bound because of some of the same Omegaverse related ideas. In any case, in explaining that lawsuit, which was the topic of Lindsay Ellis's first video, she included in the video some narrated excerpts from Addison Cain's book.
Because I am your alpha.
It was almost a roar.
And let's just say that she wasn't flattering towards Cain in her description of this lawsuit. I really like this video. I think the whole copyright case is fascinating and totally bonkers. And also in the middle has this really great explanation of how DMCA takedowns work by the YouTuber Legal Eagle.
I know a fair amount about copyright law, but I don't know anything about wolf pornography.
Yeah, that's fine.
Okay. So, the Digital Millennium Copyright Act.
That I actually told my students they could optionally watch if they wanted, while being very clear that I was not forcing them to watch an entire video that included wolf erotica in it. Anyway, Lindsay Ellis just posted a new video with an update to this saga. Basically, Addison Cain sent bogus DMCA takedown notices to Lindsay's video about bogus DMCA takedown notices. Now, to be clear, bogus is my personal opinion / analysis as someone who knows about copyright, but I think they're pretty bogus. Now, YouTube preemptively, which is weird, but again, DMCA takedown processes, topic of a whole nother video. They denied Cain's claim on behalf of Lindsay Ellis for her video. Basically, they said it's fair use.
Hold
it! So the question is, was Lindsay Ellis's use of excerpts from Addison Cain's book in her video fair use? Which means that it would not be copyright infringement, which means that it should not be taken down from YouTube. Now, Lindsay Ellis's video actually includes excerpts from the letter that Addison Cain sent to YouTube explaining why she thought it was not fair use. And that analysis of fair use was so bananas that I had to make this entire video. It also happens to be a really good excuse to explain what fair use is, and then, using that brand new knowledge, look at the wolf erotica case. So first, what is fair use and how do you know if something is fair use? Now, if you already know all of this and you want to just skip to the part about Addison Cain's particular claims, you can go to this timestamp that I'm going to put on this video. Basically, fair use is a defense to copyright infringement. So if something is fair use, it's not infringing. And to be clear, content is copyrighted by default, assuming that the content is copyrightable in the first place. And it comes attached with all of these exclusive rights. So imagine for a moment if fair use did not exist, if there were no exemptions to copyright at all. You couldn't quote a book in a book review. Parodies couldn't exist. Memes, remixes, the vast spectrum of user-generated content that makes use of underlying work, gone. Fan fiction, gone. Lots of types of news reporting, criticism, gone. For all of these reasons, fair use is considered a kind of safety valve between copyright and freedom of expression. It's supposed to balance the interest of copyright holders and public interest in the broader dissemination and use of creative work. Anyway, rah, fair use. It's super important. And of course, a brief disclaimer, fair use is part of US law. And that's what's relevant for this particular case. However, there are some similar doctrines in other countries, in particular fair dealing, which is in the UK and Canada and a lot of other countries that are part of the Commonwealth of Nations. So how does fair use work? How do you know if something is fair use? Though this is a super common misconception, there are no bright line rules for fair use. So if you've ever heard something like, you're allowed to use 10% of a book, or if you're not making money from it, it's definitely fair use. These things are wrong. No rules. Fair use is a case-by-case, fact-intensive analysis. On the bright side, this means that a fair use analysis is context dependent and can be flexible for things like new types of creative works and new technologies. On the downside, it means that you never know for absolute certain if something is fair use until someone sues you and a judge says whether it is or not. However, a lot of things are so obviously fair use that they've never really been litigated, like non-commercial fan fiction. So in making a fair use determination, there are 4 factors that are weighed. And this text comes from 17 U.S. Code Section 107, which was written in the 70s. However, there has been a boatload of case law since then that informs how these particular things are interpreted. So first, before we become the judges in Addison Cain's copyright claim against Lindsay Ellis, let me explain each of the factors, using what I think are some of the most interesting cases about each of them. Factor 1, the purpose and character of the use, including whether such use is of a commercial nature or for nonprofit educational purposes. So this factor is arguably, based on case law so far, the most important. Often fair use cases turn on this factor. There's even a really important keyword that isn't even in the language in the statute. In the early 90s, the rap group 2 Live Crew released a song that was a parody of Roy Orbison's Pretty Woman. The publisher of that song, Acuff Rose, sued 2 Live Crew and their publisher for copyright infringement. The case went all the way to the Supreme Court.
Luther Campbell, president of Luke Records and member of the group 2 Live Crew. How did it come about that you're a party to a case before the Supreme Court?
I really don't know. It's the weirdest thing ever, ever happened to rap music, I think. See, Roy was the conservative, upper class version. Now we finna play the hood version. See, that's the difference. That's the big deal there. This is, people in the streets can relate to this.
Spoiler, it worked out for them. And in fact, this became one of the most important fair use cases of all time. So in 1994, the Supreme Court held that 2 Live Crew's use of Pretty Woman was fair use. They focused on the new work as a parody. And they pointed out that, like criticism or news reporting, something is not automatically fair use by virtue of being a parody. However, they specifically interpreted purpose and character as meaning that the more transformative the new work was of the original, the more likely it was to be fair use. In fact, the more transformative it is, the less all of the other factors matter. Additionally, whether something is of a commercial nature is only one part of this factor. In the 2 Live Crew case, the court found that the fact that they profited off of the song did not weigh heavily against the other factors enough to find that it wasn't fair use. And this established transformativeness as being very, very important in fair use analyses. Another way that this can be interpreted is transformative purpose. 2 more really interesting and famous fair use cases that involve technology turn on this in particular again. The first, Sony v. Universal, is about the Betamax. If you don't know what a Betamax is, think VCR. If you don't know what a VCR is, then, I don't know, look it up and I'm old.
Hey, now that's just, that is, wow, what is that? This is the Sony Betamax. Console TV, right? No, not quite. Betamax is a totally new concept in television entertainment.
Basically, the movie industry lost their minds when they realized that people could copy movies off of their TV.
What's inside the little box? Oh, this is a Betamax cassette. Now, it's very much like an audio cassette, except that with Betamax, you record both picture and sound on the same videotape.
That case also went all the way to the Supreme Court in the early 80s, and the Supreme Court determined that it was fair use because the purpose of copying something with a Betamax was not to copy something, but to time shift it so that you could watch it at a different time. Similarly, in 2007, there was a case involving the men's magazine Perfect 10. The court determined that the use of images from Perfect 10's magazine covers in Google image search was not copyright infringement. It was fair use because of a highly transformative purpose. Purpose of thumbnails and image search is not for aesthetics, entertainment, etc., but instead as a search engine. Imagine if VCRs and image search were illegal. Both of those cases actually could have drastically changed the course of technology from then on. And another example of transformativeness, if you remember the case about the Harry Potter lexicon from 2007, J.K. Rowling sued the creator of essentially a kind of Harry Potter encyclopedia, which was also commercial. Now, Rowling did win that case, in large part because there were long passages cited without transformation, in particular from the Harry Potter reference books, Quidditch Through the Ages and Fantastic Beasts and Where to Find Them. But importantly, the court was careful in pointing out that that was specific to this case. But reference books in general for fictional media are transformative because, like Google image search, the purpose is reference, not aesthetics or entertainment value. Now, all four of the cases that I just pointed to happen to be commercial use. That's in part because they're the most likely to be litigated, which is in part because if you're, say, an amateur remix artist and you get a cease and desist letter, you're probably just going to cease and desist instead of hiring a lawyer. But suffice it to say that despite a common misconception, whether something is commercial or not is not the sole deciding factor of fair use. And in fact, most of our case law is about commercial uses. That said, if your work is non-commercial, particularly if it's educational, that does weigh heavily in favor of fair use. Next up, factor 2. The one that everyone forgets about because it's not actually that important most of the time. The nature of the copyrighted work. This factor essentially covers two things about the underlying work, whether it is published or unpublished, and whether it is fiction or nonfiction. Basically, if the underlying work is something like a private correspondence or an unpublished manuscript, that weighs against fair use, in part because you want to give the copyright owner right of first publication. Though I actually can't think of any cases I know of that were about unpublished work, so the vast majority of the time this doesn't matter. Courts also give greater protection to creative works. So this means that fair use should apply more broadly to fiction than nonfiction. That said, again, I don't tend to see a lot about this factor in fair use analyses and decisions, though it's sometimes noted that this weighs against fair use if the underlying work is a creative fictional work. Decisions just tend to be more strongly based on the other factors. Okay, factor 3. The amount and substantiality of the portion used in relation to the whole. Basically, how much of it did you actually use? Again, no bright line rules. The law does not actually set any kind of quantity limits. But generally, the more you use, the less likely you are within fair use. Consider, for example, a fan vid, a type of video-based fan work in which scenes from movies and TV shows are spliced together and remixed, typically set to the background of a single song. The OTW has been involved in legal proceedings around protecting the validity of fan vids, specifically for exemptions to anti-circumvention laws, which again is the topic of a whole nother video, but I will link down below to some resources about that if you're curious. But I wanted to use an example from OTW's test suite of fan vids where there are explanations of why these are valuable, fair use, etc. So this is a women's work, a supernatural fan vid from Luminosity and Sisabet. So this is where the song Violet by Hole would be playing. However, when I uploaded this video to YouTube, it got flagged by the Content ID system. And though normally I'd be pretty jazzed to file a counter notice on grounds of fair use for reasons that will become clear later, I did promise to post this video tomorrow and don't really feel like waiting. So we're just gonna let the irony lie. And also you'll see a link below to OTW's test suite of vids, and you can watch this fan vid with the appropriate music there. This vid cuts together scenes of women from early seasons of Supernatural in order to show that, especially at that time, women in the show were mostly victimized, sexualized, and demonized. It's 3 minutes out of countless hours of Supernatural. The amount and substantiality of Supernatural used in this fan vid is very, very small. So that would weigh strongly against a finding of copyright infringement of Supernatural. That said, if the claim was instead for the song, which is Violet by Hole, it is the entire song, so this factor would likely weigh against fair use. Similarly, consider Buffy vs. Edward, which is a remix video from Jonathan McIntosh.
Not late, not late, the bell rings. Uh-oh.
It's a feminist critique of Twilight.
I've killed people before.
And you're sure this isn't just some fanboy thing? Because I fought more than a couple pimply, overweight vamps that called themselves Lestat.
I wanted to kill you.
Spoiler, Buffy stakes him at the end. It uses about 5 minutes out of 7 seasons of Buffy, and a couple of minutes out of the first Twilight movie. Super easy case of fair use between factors 1 and factor 3. In fact, McIntosh spoke in front of the Copyright Office with this as one of the examples of remix. In spite of this, Lionsgate, the owner of Twilight, still sent DMCA takedown notice, which I would also describe as bogus. And finally, factor 4, the effect of the use on the potential market or value of the work. This factor is often referred to as market harm. Essentially, does this new work somehow deprive the copyright owner of the opportunity to profit off of that work or potential new markets for that work? So one way to think about this is, does having this new thing somehow mean that people would not pay money for the original? For example, would someone watch this 2-minute Lego stop motion version of Star Wars The Phantom Menace instead of watching Star Wars The Phantom Menace? Probably not. Unlikely market harm. But what if you created a remix of Phantom Menace in which it was exactly the same, except there were black boxes over Jar Jar Binks' face, so you didn't have to look at it, but otherwise exactly the same? It is actually possible that someone would download and watch that version of the movie instead of buying the original. So potential for more market harm. One of my very favorite examples of a market harm analysis is from the case SunTrust v. Houghton Mifflin, which is about Alice Randall's 2001 novel, The Wind Done Gone, which, by the way, I recommend reading. The Wind Done Gone is an alternative telling of Gone with the Wind from the point of view of Scarlett O'Hara's slave half-sister. Now, Margaret Mitchell's estate actually officially licenses sequels to Gone with the Wind. I read one when I was in middle school. It was terrible. But that means that in theory, they could have officially licensed this book and therefore profited off of it. However, they had very specific guidelines for authors and actually made them sign a pledge that they would not include any mentions of interracial relationships or homosexuality, which means that they probably would not have been fans of The Wind Done Gone, which included, again, Scarlett's half-black sister and a very gay Ashley Wilkes, which, you know, improvements over the original. And as the court pointed out, The Wind Done Gone, for these reasons, probably would have had little appeal to fans of the original. So, no market harm. In fact, this brings up another very important point about what market harm is and is not. It is not about criticism of the underlying work. As the judge in a 1986 case wrote, the economic effect of a parody with which we are concerned is not its potential to destroy or diminish the market for the original. Any bad review can have that effect, but whether it fulfills the demand for the original. Hear that? Bad reviews are not market harm. And in the case of The Wind Done Gone, Margaret Mitchell's estate tried to block the publishing of the book because it would seriously taint the reputation of the original. Copyright protects the market for the work, not the reputation of the author. Now, there are some things called moral rights, which are stronger in some other countries than they are in the United States, but essentially here, copyright not equal to reputation. So, as the court said in that case, you can't use copyright to stifle criticism. That goes against the entire point of copyright, to promote free expression, and again, is in part why fair use exists. In fact, a few years ago, someone purchased the rights to a photograph of himself from the original photographer just so that he could sue a blogger for copyright infringement because he was mad about what the blogger was writing about him. This did not fly. He lost. So that's fair use. Now, let's go back to our case study. Again, the question here is whether Lindsay Ellis's use of excerpts from Addison Cain's book in the video about the Omegaverse lawsuit was fair use. So here's what that use looked like.
Because I am your alpha.
It was almost a roar.
It is a total of 2 or 3 minutes, mostly at the beginning of the video. A narration of a total of about 400 words of Born to be Bound. Now let's take a moment to check out the fair use analysis as sent by Addison Cain to YouTube.
The work infringed is not fair use. My book is not public domain. It is a creative work, not a textbook. The poster significantly transformed my original work, both by altering the work and by mocking it for the poster's financial gain via YouTube and Patreon. Monetizing the video does not make this fair use.
Now there's also something about a baby and Lindsay Ellis being a menace, neither of which I think are that relevant to copyright, so we will stop there. Now let's break this down using the elements of fair use that we just learned about. But let's start with actually a general element of copyright. My book is not public domain. This is a factual statement. And get ready, because I'm going to sound like a broken record on this one, totally irrelevant. Public domain refers to a work that is not protected by copyright. Most of the time, this is because copyright has expired, which, if you didn't know, takes a really, really long time. Thanks, Mickey Mouse. But public domain is why we can have 10 film versions of every single Shakespeare play and Jane Austen novel. Or, like, this retelling of Jane Eyre in Space by my friend Alexa Dunn. But Cain is right. This ain't Jane Eyre. If it was, Ellis wouldn't have had to make a fair use argument at all. She could have narrated the entire book in the video if she wanted to. Okay, so back to fair use. Factor 1, the purpose and character of the use. The poster reads my book to degrade my work.
Objection!
This is probably true, but if not totally irrelevant, actually weighs in favor of fair use. Again, the purpose of fair use is to serve as a safety valve between copyright and free speech. As the judge said in the Wind Done Gone case, copyright should not be used to try to stifle criticism. Copying works in order to, well, degrade them, criticize them, is part of why fair use exists in the first place. We can't write book reviews about why books are really bad if we can't quote from the books. Plus, if the passage had appeared with the exact same purpose as the original, to entertain people, this actually would have been less transformative than Ellis's actual use. So as a criticism, this is a big thumbs up in column 1 for the first factor of fair use. The poster significantly transformed my original work, both by altering and by mocking it. Okay, now you're just messing with me, right? It literally uses the word transformed.
Objection!
So, yeah, altering the work, transforming it, mocking it even, makes it more transformative. So, big thumbs up for factor 1, fair use. The fact that Ellis blacked out the naughty words actually made it more transformative too. Monetizing the video does not make this fair use.
Hold it!
So yes, monetizing it does not make it fair use. Monetizing it also doesn't make it not fair use. Again, most of the examples that I gave of fair use cases were for commercial work. And in the 2 Live Crew case, they essentially said that the more transformative it is, the less everything else matters. I hope that Alice Randall made a boatload of money from When Done Gone. So yes, commerciality does weigh against fair use for the first factor, but in practice, it tends to be outweighed by heavy transformativeness. In sum, my assessment is that because of transformativeness and criticism, the first factor weighs in favor of fair use. That said, if Ellis made money from it, that does weigh a little bit against fair use. Factor 2, the nature of the copyrighted work. It is a creative work, not a textbook. Also true. Probably not that important in the scheme of things, but totally true. I mean, I don't know about you though, but then I'm immediately wondering like what an Omegaverse textbook would look like. I don't know, maybe the guy who made the Harry Potter lexicon should get on that. There could be a market for that kind of thing. Anyway, this goes to factor 2 of the fair use analysis, the one that people don't talk about that much. So Addison Cain's work, first of all, is published. Of course, doesn't really matter, but weighs slightly in favor of fair use. Also, it's fiction. As Cain says, it is a creative work, not a textbook. So this does weigh slightly against fair use. Though to be clear, textbooks are still covered under copyright. But to be fair, this is probably the most valid point in the entire analysis. It also happens to probably be the least important. Factor 3, amount and substantiality. So Cain's analysis didn't bring this up specifically, at least not in the part that Ellis quoted, probably because there's no helpful argument for her here. But according to this handy website that calculates the word length of books based on audiobook length, Born to be Bound is about 50,000 words. Ellis's video uses about 400 of those 50,000 words, or probably less since she bleeped out the naughty ones. So this factor weighs clearly in favor of fair use. And finally, factor 4, market harm. Though I'm not sure if this was actually part of her fair use analysis or not, at some point Cain did point to the fact that her book is getting 1-star reviews after Ellis's video. But again, this isn't relevant. As I pointed out before, reputational harm is not what's meant by market harm. If a critical parody causes people to like something less, that's free speech. Like, years ago, I had my very first taste of internet fame. I created a feminist remix of this bafflingly sexist book called Barbie, I Can Be a Computer Engineer. So TLDR, the plot is basically that Barbie tells Skipper she's making a game, and when Skipper asks if she can play it, she says, "I'm only coming up with the design ideas. I need Steven and Brian to help me make it into a real game." And then she infects her computer and Skipper's computer with a virus, and the boys make the game and fix her computers. Yeah. In this fit of dissertation-fueled procrastination, I took the entire book, blanked all the text in Photoshop, and wrote something new. Anyway, in my version, Barbie can actually code, Steven has a pink laptop, and we learned about teamwork. And also sexism. In any case, yeah, my remix made Mattel look bad. In fact, they pulled the book from publication, which means they didn't make any more money from it. Did they sue me? Or the blogger who originally posted the text of the book online? No! In fact, a few years later, they hired me as a consultant for a new book they were working on. See, that's classy. Someone could learn from that. Anyway, I'll link down below to a fair use analysis I wrote about all that stuff, now that I know you really want to practice. So unless someone who legitimately was going to purchase Born to be Bound decided that instead they could get the same thing out of 400 words of it, this wasn't market harm. In sum, I feel pretty confident, given this analysis, that Lindsay Ellis's use of the copyrighted work from Addison Cain was fair use. YouTube and EFF agreed. Now, I don't want to make any assumptions about Addison Cain's lawyer, but I'm assuming that EFF and YouTube both have people who are really significant experts in copyright. Now, to be clear, Addison Cain is not the first person to make a bad fair use analysis. Again, a big chunk of my dissertation was specifically about how people get fair use wrong and why there are misconceptions about it. In fandom, for example, there are really strong social norms about copyright, some of which do not track fair use at all. There are things that people think matter for fair use that don't, like attribution or disclaimers. All those disclaimers you're writing on your fan fiction, they mean nothing. It's not unreasonable that people don't understand a lot about lots of parts of copyright law. And fair use in particular is so case by case and subjective that it's reasonable that people could get it wrong. But there are some serious imbalances of power in copyright law, and DMCA takedowns should only be used when you have a well-reasoned, good faith belief that copyright infringement is taking place. And, in my opinion, only when you're actually being harmed. Leave the remixers alone. I've actually been doing some research lately about how DMCA takedowns impact fan creators. Because sometimes you don't even need someone like Addison Cain to send a DMCA takedown. YouTube's got algorithms. And the process of fighting a copyright claim can actually be really scary. In part thanks to ridiculousness like this part of YouTube's copyright school video.
Mashups or remixes of content may also require permission from the original copyright owner, depending on whether or not the use is a fair use. In the United States, copyright law allows for the fair use. If you are uncertain as to whether a specific use qualifies as a fair use, you should consult a qualified copyright attorney. But be careful. If you misuse the process, you could end up in court. And then you would get in a lot of trouble. That's how the law works.
Basically, they make it seem like filing a counter notice is something that you need to hire a lawyer to do. Anyway, I have a lot of feelings about this. But the point is, protecting your copyright is important. I want creators to be able to profit from their work. However, copyright should not be used as a weapon to shut down criticism. And to be clear, I am not commenting at all on claims of defamation because I'm not an expert on defamation. And unlike everyone who thinks they know everything about copyright, I don't like to comment on things I'm not an expert on. Also, to be clear, if you are watching this video, you need to absolutely take the same advice that Lindsay Ellis gave in her last video, which is do not go harass Addison Cain. You're only making things worse. And also, while I'm here, you might be wondering if I am part of the fan fiction deep state. Because again, I'm on the legal committee for OTW, which Addison Cain has some feelings about, apparently.
Your organization, the Electronic Frontier Foundation, EFF, is a close partner with the Organization for Transformative Works, OTW, and was clearly working with Lindsay Ellis on the video.
The people who own AO3, the fanfiction website?
Yeah, Lindsay, I was just as confused.
In this case, the fact that the EFF has worked with OTW before on completely unrelated things means that there is a fanfiction deep state keen on taking Addison Cain down.
Gotcha!
To be clear, OTW as an organization has nothing to do with the Omegaverse litigation. They don't have anything to do with this video either. So if I got anything wrong, assume that it's definitely me and not the OTW lawyers who are actual lawyers. And yeah, I don't know Lindsay Ellis either, except I do have a copy of her book. I've read that much of it. I like it so far. I actually think it might be a nice selection for the speculative ethics book club that I run. So if you've read her book and you liked it, I'll leave a link below in case you want to check that out. Plug! Anyway, hi Lindsay. I hope you don't mind all of the fair use I made of your videos for making this one. And I ended up barely talking about fan fiction at all. So clearly there will be more videos along these veins. I've really been wanting to talk about 50 Shades of Grey and copyrightability and social norms and fandom. Maybe that's up next. And if you missed it, my first video essay about fandom is about fans' migrations across online platforms with some real blasts from the past and the history of Archive of Our Own. I also make videos with advice for graduate students. I hope you enjoyed this. Consider subscribing. As an academic, still trying to convince myself this is a good use of my time. If there's anything that you would like to add to this, any nuance in the fair use analysis or something that I explained, please leave that in the comments below. You can ask me questions about fair use, but I'm not going to give you legal advice. And if you really like this video, why don't you go remix some wolf erotica? You can probably find some on Archive of Our Own for free. Rah rah fair use. All right, I'm Casey. Thanks for watching.